Realtors play an important role in helping keep proceeds of crime out of BC real estate markets. During a transaction, real estate brokerages ask for and verify certain personal information of everyone involved. In most cases, brokerages delegate this responsibility to realtors. Providing this information helps prevent money laundering and the financing of terrorist activity, which helps protect the integrity of Canada's financial system. It also helps to ensure that your realtor meets their legal obligations. What information will a realtor ask for? Realtors are required to obtain, record, and retain the personal information of their clients, including date of birth and specific occupation. To do this, they'll ask to see your government-issued identification, such as a driver's license, passport, or residency card. This information will be kept on file in the realtor's brokerage for 5 years. But there's no requirement to keep copies of government-issued identification, just the information on it. If you have taken part in a transaction with a particular brokerage within the past 5 years, depending on the brokerage's policies, a realtor may ask questions to confirm if the information you had previously provided is still current. If it's not, the information will need to be updated. Alternatively, they may collect your identification for each transaction. Under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act, and the federal agency responsible for compliance, the Financial Transactions and Reports Analysis Centre of Canada, FINTRAC, realtors are required to assess the level of risk of a money laundering offence or terrorist activity financing offence in any given transaction, and may ask you additional questions or seek additional identification documentation in order to do so. These requirements also affect a buyer or seller who is not using the services of a realtor. If there is a realtor involved in the transaction, they will request the personal information of the unrepresented party to verify that private buyer or seller's information. So is that all the information a realtor will ask you to provide? There are aspects of your real estate transaction that might prompt your realtor to ask you for more information to comply with their legal obligations. For example, you may be asked whether you are acting on behalf of a third party while conducting your transaction. This means you are following the instructions of someone else when completing the transaction, or someone else, whether an individual or company, may have an interest in the transaction. If there is a third party involved, your realtor is also required by law to obtain their identification information and to keep that information on file for 5 years. The Proceeds of Crime, Money Laundering, and Terrorist Financing Act requires realtors to keep identification records and to track all funds, not just large amounts of cash, used during a real estate transaction. And each time funds are received by a brokerage during the transaction, the brokerage is required to record the amount received, how it was obtained, and account details relating to the funds. An example of funds received as part of a transaction that need to be recorded would be the payment of a deposit. If you're not able to meet face-to-face with your realtor to show your identification information, then the realtor may use an agent or mandatory to identify you, or use other methods for verifying your identity. It's important to know that when you provide your personal information to your realtor in connection with a real estate transaction, your information may only be collected, used, and disclosed in accordance with applicable laws. An example of disclosure may include responding to a request from FINTRAC. Want to know more about the role realtors play in anti-money laundering and helping ensure consumers are well protected? Ask your realtor. Realtors are here to help.